Hi, everyone. My name is Chloe Chapman. I'm a staff attorney in the Housing Stability Program at Eastside Legal Assistance. Today, we will be going over pay or vacate notices, which is something that a tenant might receive if they have fallen behind on their rent or other recurring charges. So I'll start with an overview of our program. Eastside Legal Assistance Program is a nonprofit dedicated to working with people who are facing various legal issues. This could include domestic violence, housing, financial, healthcare, or immigration. We also educate communities about their legal rights through webinars such as this. We know that not everyone can afford a lawyer, and we want to make sure that everyone has access to legal help. So our legal services are free for those who qualify. Here is what we will go over today. We'll start with what a pay or vacate notice is, and then we'll go into what you as a tenant should do if you receive a notice. We will review your options to address a pay or vacate notice, and we'll discuss the eviction process. So the first part is what is a pay or vacate notice? This is a physical document, a piece of paper that is given to you by your landlord if you have not paid your rent or other recurring charges in full. So you have an outstanding balance. Here is an example of what a pay or vacate notice looks like. We'll go over the parts of the notice, but they can look really different, and it's important to make sure that the required pieces are included, but the overall format could change from landlord to landlord. This is the first step in the eviction process, so it is really important that you pay attention to any documents you receive from your landlord. So some reasons that a tenant might receive a pay or vacate notice include not paying your rent on time. So even if you've paid after the grace period that is included in your lease, the landlord could still issue a pay or vacate notice. Another reason might be that you've had a rental increase and you have not been paying that new amount. So you're left with a balance. And really, if there's any type of outstanding balance, your landlord can issue a pay or vacate notice. Another common issue that we see is actually an error in the landlord's accounting. So maybe they put the wrong rental amount in, or there are duplicate charges. And that is something that an attorney could help you with to fix what we call a ledger. But it is common that their accounting is off. So it is important to pay attention to your ledger if you have access to it. So here's a breakdown of a pay or vacate notice, and just keep in mind that the format could look different because this is not an official form or template. So first, the tenant's name and address must be listed. So you'll see in that box that's highlighted where that might go. Next, the notice must explain how much time you have before the landlord can start the eviction case. Typically, we see a 14 or 30-day notice for pay or vacate issues. The 30-day notice is becoming more common, but there are certain properties that have to use that notice. So if you have questions about that, you should be reaching out to an attorney. The next portion that should be on the notice is a month-by-month breakdown of the balance, just to show what it is that you have not paid. And that is important because landlords are only able to evict based on non-payment of recurring charges. So that would be your rent, your utilities, and other recurring charges that are included in the lease. And so it's really necessary for you to look at this and see if the charges that they're alleging have not been paid, are accurately listed. The notice should also include a total of outstanding balance, and that is the amount that you would have to pay off in order for the notice to be cleared up, basically. And so you'll want to check that that total amount also looks correct. So some questions, we'll go over some questions that commonly come up for tenants. The first is the issue of service. And service is just a legal term for giving someone documents. They can either be handed to you or posted on your door and mailed. And so there may be some issues where the landlord is trying to email you the notice, and that really is not acceptable. So every pay or vacate notice must contain the elements that we went over, the name of the tenant, their address, itemized list of the charges, and the total balance. It also must be made in physical writing. So as I explained, the landlord cannot text or email this to you. This has to be a physical document that's provided to you. And the landlord can serve it on a tenant in two ways. One, it can be hand delivered to you or a suitably mature person at your residence. So that can't be a minor, that cannot be a person with disabilities that are so serious that they don't have competence to accept the delivery. If they don't hand deliver you the notice, the landlord can alternatively post the notice on your door and send a copy in the mail. So if you see something posted on your door, you should also look out for a copy coming in the mail. And there is an issue if they did not send it in the mail, but that does not mean you should ignore the notice. This brings me to a very important tip. You should document everything. Documentation is your best way to keep a record of what has happened in your case. Your attorney needs to know this information, and it's possible that it would become relevant in the actual court case. So take note of when you've received documents, keep emails and other written communications that you have with your landlord, and just take really good notes of your case so that you can remember that when it comes time that the information is needed. Let's go over some other questions that might come up. First, why does my notice say I have 14 days instead of 30 or vice versa? So a 30-day pay or vacate is a special type of notice that landlords have to give if they have a federally backed mortgage or they have tenants that receive federal funding. So that does not include most landlords and their properties, but just anecdotally, we have seen a lot more 30-day pay or vacate notices sent out as opposed to the default 14 days, because landlords are probably just wanting to be safe and make sure they cover their bases. So whatever it says on your notice is how much time you have, but there might be some reasons that you should have gotten a 30-day notice. And that's why it's really important that you seek legal assistance as soon as you receive anything like this. Tenants also frequently ask whether they should start to plan moving out if they receive a notice. You don't have to move out. There is a long eviction process to come after the notice expires, which we will get into, but it can be helpful for tenants to think about where they might want to move, especially if that's a more affordable option for them. And if they're having trouble making their rent payments, it's not sustainable to stay in the unit. But this could be a good time for tenants to start looking for new housing. They just don't have to move out by the end of the notice period. Which brings me to the next question. Do I need to move out when the notice expires? You'll see a date on the notice as to when that expires, and a lot of tenants read that as the date that they need to move out by. That's not true. The landlord has to win the eviction court case to actually have you legally removed. But often landlords will convey the message to tenants that they need to move out by the end of the notice, and then tenants end up self-evicting. So we really encourage folks not to self-evict unless that is the best option for them, and an attorney can have that conversation with you about your options. Eviction, actually vacating the property might allow you to avoid the eviction case, but that doesn't mean that the debt doesn't follow you. So there are consequences to self-evicting, and you should speak with an attorney before you decide to do that. Another kind of practical tip, you do not need to sign anything that your landlord gives you. And we really would not advise you to sign anything without reading it first, but even better if you can speak to an attorney before you sign something. At this stage, before the eviction case has started, landlords might try to get you to settle and sign something. And we just want to be very careful about the potential consequences. So you're not required to sign anything. You may choose to, but you should consult with a legal professional before you make that decision. Further, a landlord cannot force you to evict or to vacate. They can't force the eviction without actually getting the court order. And that requires them going through the court process, filing the court documents and serving you with them, and then giving you an opportunity to respond and have a hearing. So that takes much longer than the pay-or-vacate notice, that 14 or 30 days. And it's just really important for people to remember that they cannot be legally removed from their unit without a court order. And finally, if you are locked out of your apartment or unit without an eviction court order, you should contact legal assistance. There are, that is something that a landlord cannot do. They cannot just change the locks and lock you out of your unit because they want to evict you. And so there may be some remedies there. Okay, moving to the next part about what tenants should do when they receive a pay or vacate notice. The first step is verifying the balance. So you'll see the total amount listed on the pay or vacate notice. And if you're able to look through your records and make sure that that balance is accurate, that's the first step in responding to a notice. So you can verify the balance by requesting a copy of your ledger. A ledger just shows all of the transactions that you've made as a tenant. So it would show when you paid rent, the dates that you make payments, and it would show how much the landlord is charging you for things. So it's really a good first step to request that copy from your landlord if you don't already have access to it, and compare it to your own documentation of payment history, going through your bank records, and just making sure everything is accurate on the ledger so that you know the balance is correct. If you notice some issues and you want, you can discuss them with your landlord without an attorney. We always advise people to make contact with their landlord through written communication, whether that's email or text or letters. That just helps keep a better written record of the conversation. But if you feel that the issue is a little bit more complicated than you're comfortable handling, you should speak to an attorney before you reach out to the landlord. Next, we will consider your options. So at this point, you have verified that the balance is accurate and you're figuring out how to pay it. The first step would be to attempt to negotiate a payment plan. Landlords are not obligated to enter into a payment plan. That they used to during COVID, but that's not required anymore. It's still worth asking your landlord if they could break up the balance over 3 or 6 months, just to give you some time to catch up and save some money. If you're able to pay the remaining balance, that should be the priority. At this stage, now that you've received the pay-or-vacate notice, your landlord is only obligated to accept payment for the full balance. So if you can't pay the full balance, you could, going back to the first option, negotiate a payment plan. You can also look for rental assistance. And at Eastside Legal Assistance Program, we have a resource list that we can send out to tenants that includes organizations that offer rental assistance. You will have to apply to those individual organizations, and it can take time. So we always encourage folks to apply as soon as they know they might need financial assistance. If there is no rental assistance available, your options are to leave the unit, and that's what we call self-evicting, or wait to receive the court documents. And we'll talk more about the eviction process, but currently there is a really significant backlog in the King County courts, and it's taking a while for these cases to actually make their way through the court. So tenants during that time are able to stay in their unit. Like I explained before, you can't be legally removed until the landlord has won the court case. And so tenants may choose to stay in their unit and wait until the court case is finished. And just a reminder again to document everything, dates, times, if you made a payment and it hasn't been processed, all of those things is information that your attorney would like to know when they take your case. So now we will review the eviction process, because the pay-or-vacate notice is the first step in the eviction process, and then often tenants are left wondering what will come next. So here are the steps. First, the tenant would receive a pay-or-vacate notice. Again, those are 14 or 30 days before the notice expires. And after the notice expires, the landlord then has the option to start the court case. Some landlords will wait well after the notice expires. It's up to them when they want to start the court case. And some might wait because they don't want to pay the filing fee, the court costs, or pay an attorney to start the eviction case. So there might be a significant amount of time between when the notice expires and when you actually receive court documents. But that next step would be for the tenant to receive and be served with a summons and complaint. Those are court documents that actually start the eviction case. It's really important to note that there is a response deadline that comes with the summons. So if you receive anything that looks like court papers, you should be contacting an attorney. And we'll provide some information on how to contact an attorney at the end. But if you fail to respond to the court documents, that could make it easier for the landlord to win, and that can happen a lot sooner. And so that could just speed up the eviction process. And we really want to make sure that folks are responding and being given an opportunity to have their day in court. So assuming the tenant responds on time, everything has now been filed in the case with the court, and the court will set what's called a show cause hearing. As I mentioned before, there is a really serious backlog in the King County courts. It's taking up to 6 months to get this show cause hearing scheduled. So there's a really significant delay in the eviction process, which can be frustrating for landlords and might cause them to push tenants to try to self-evict. But just keep in mind that the court process needs to run its course, and you don't have to move out. If the landlord wins, the court will issue what's called a writ of restitution. And that is basically the court order that says the tenant needs to vacate. And then the sheriff, in the next few days after that writ has been issued, the sheriff will come to the residence and actually evict the tenant. They might give them 24 hours before all of their belongings are moved out of the unit. So that's really the end of the eviction process, is the writ of restitution that is executed by the sheriff's office. And that is the point at which you actually have to vacate. There is really no ability to get around the writ once it has been issued. If you think something went really seriously wrong in your eviction case, there may be one last option to stop the eviction, but you should speak to an attorney about that. So here is a court summons. They will look very similar because this is a court form, unlike the pay-or-vacate notice. And I'll go through the portions of it. At the top, we have what's called the case caption. That shows the name of the parties. So the landlord or their company is the plaintiff, and the tenant is the defendant. If the case has been filed, you'll see a number here, and you might see the stamp showing that it was filed with the court. It's helpful to know whether the case has been filed or not, because if it hasn't been filed, you just need to give your response to the landlord's attorney. But if it has been filed, you would also need to file your case in court. Again, these are things that an attorney can help with, but just for your understanding, there is a difference between a filed or an unfiled summons. We can also show you how to look up your case information to find out if the case has been filed. So please do contact an attorney if you receive this court document, and we can help. The next portion of the summons is the response deadline. They're going to put that in big bold letters as to when you need to submit your written response. If you receive this and you wait a day before the response is due, it's going to make it really difficult for an attorney to help you on time. So please pay attention to any documents you receive, read them thoroughly, and note any deadlines that might be listed. And finally, the other part of the case caption up here is the category, so you can see that this is for an eviction. So we already discussed whether or not the case is filed. This section that we've circled is just another way to see if it's been filed. But this page really provides all of the instructions to respond. When you respond, you will want to pay attention to the address provided in this area, in this section. It just gives you the information to send your response to the landlord's attorney. At this point, there won't be a hearing scheduled. You would get another court document sent to you to provide notice of the hearing. So as we just reviewed, the elements that must be included in the summons. This again is really similar to the pay-or-vacate notice, where it has to be a physical document. It can either be hand delivered to you or a suitably mature person at your residence, or it can be posted to your door and sent in the mail. So very similar to the pay-or-vacate notice service that we discussed. If you want more details about your case, and you see that if you see that the case has been filed because there's a stamp on the summons and a case number, you can go to the King County Superior Court Clerk's website and access the Casey Script portal. That allows you to see certain case details. You can also purchase documents from there. And the search looks a bit like this. We just tried to provide some screenshots, but you would want to select the second case type, civil, and then you can either type in the case number if you have it, or you can search your full name. There's an option to just search your name and see what comes up. That will get you to your case details. You can see if a hearing has been scheduled, and you can see if anything else has been filed in the case. And then, like I said, you can purchase and view documents. You do not have to have an account for this, but sometimes it is a little bit easier if you create an account. All the accounts are free, so it's your choice whether you want to create an account. As I said, make sure you respond by the deadline. Even if the case hasn't been filed, you do still need to respond, and an attorney can help you with that. So next, we will review how to get help from an attorney. And you might be working with us at ELAP. We might be referring you to other organizations that provide housing support, but a lot of these tips apply generally. So if you have received an unfiled summons, again, this would be a court document that does not have the case number on it, you should be contacting one of these 3 nonprofits. If you live in King County, but you do not live within Seattle city limits, you can contact us, Eastside Legal Assistance Program. If you are within Seattle city limits, you should be contacting the Tenant Law Center. And if you are outside of King County, you can contact the Northwest Justice Project. These are all nonprofits that provide free legal services to low-income tenants, so you will have to be screened to make sure you're eligible. If you have a filed summons and/or you already have a court date, you should be contacting the Housing Justice Project. The King County branch of the Housing Justice Project is under the County Bar Association. So they're a smaller nonprofit, but they do really great work to support tenants in their eviction case. They can provide free representation if you qualify, and they will help you to work on defenses to your eviction, possibly negotiate with your landlord. So if you're already in the stage where the court case has been filed, that's who we would direct you to. And it's really important that you get in line because there are a lot of people that are requesting those services. Outside of King County, there are other housing justice projects. If you contact us at ELAP, we're happy to connect you with those organizations. Anyone who does not qualify for services because they make too much in income would need to consider contacting a private attorney. We do not offer direct referrals, but we can point you in the right direction to find a private attorney. There's also a moderate means program that may become available later in the year, but currently they're not accepting clients. So if you think you might not qualify because you make too much income, you should still contact us and we'll try to connect you to some resources. Here are some tips for an effective attorney-client dynamic. As I said before, if you can contact an attorney as soon as you know there's a problem, we're going to have enough time, hopefully, to help you. So as soon as you receive that pay-or-vacate notice or court documents, you should give us a call and get in line because, again, there are a lot of people seeking these services, but we try to reach everyone that we can. So just give us a call, fill out an intake form as soon as you know that you might be under threat of eviction. Before you meet with an attorney, it is highly recommended that you gather and organize your paperwork and your notes. The attorney is going to need specific information from you, and if you spend your whole time on your intake call with the attorney looking for the paperwork, that's not going to be a very productive meeting. So please try to do that before you meet with an attorney, but we can also help you organize if needed. Attorneys rely on consistent communication. You will need to explain to your attorney the method of communication that works for you. If you don't use email, you should tell us, and we can just make phone calls. But the only way for us to work with you effectively is if you tell us what you need and maintain consistent communication. There may be deadlines that come up. There are always going to be things that the attorney needs your consent to do. And if we can't reach you, it just makes our job really hard. So please do ensure that you have a reliable form of communication for your attorney. And the bottom line is you have to be really honest with your attorney. There are potentially embarrassing things that you might not want to share, but if we don't know all of the information, it will be very difficult for us to help you. We deal with people at some of the worst stages in their life. Nothing is out of the ordinary to us, and we really work to be judgment-free and meet people where they're at. So even if it's embarrassing, even if you feel that that's bad for your case, you should still tell your attorney. Your communications are confidential. They're protected because you're speaking to your attorney. And that information might be really useful for us to actually win your case. So that is the end of the presentation. If you have questions, you can email us at housingintake@elap.org. We really strive to serve everyone in the community, no matter their situation or income. So if you have a legal issue, please contact us. And if you're not eligible, we will try to connect you with resources. We just want to ensure that everyone has access to legal services if they need it. I will then leave our phone number. This is our main phone number. You can call it and it will be directed to the housing team. You can also visit elap.org and fill out the online intake form, and then we can contact you to provide services. Thank you all for attending this webinar. We really hope that this was educational, informative, and we hope that we're able to assist you with your legal issues. So please do reach out. Thank you.